Hi everyone, my name is Sasha Eisenstein. We're pleased that you could all join us for this week's lecture, Volume 9 of the KnowNeuropsychology Didactic Series that brings you lectures from experts in the field covering different topics each week. The series was created by trainees and early career neuropsychologists, including standing members of the KnowNeuropsychology Board, as well as members of the KnowNeuropsychology Committee. Before we start our lecture, one of the main goals of KnowNeuropsychology is to provide free, high-quality didactic content to our audience. Every KnowNeuropsychology and KnowNeuroanatomy lecture is available on our YouTube channel. Be sure to check it out, subscribe, and like our lectures to get first access to new content. We want to remind everyone about our collaboration with Absen to bring you learning and discussion questions that are provided with specific lectures content. You can access these on our website and through Absen. Here are the disclaimers for the series. This training is not meant to replace formal education in neuropsychology, and the views of the speakers are their own. Questions can be submitted via the Q&A box on the lower left of your screen, and a recording of today's lecture will be provided on our website and YouTube channel later this week. Now it's my pleasure to introduce Dr. Michael Brook for today's lecture titled Introduction to Forensic Neuropsychology Practice. Dr. Brook is a board-certified clinical neuropsychologist and an associate professor of psychiatry and behavioral sciences at Northwestern University's Feinberg School of Medicine. He received his doctorate degree in clinical psychology from Rosalind Franklin University of Medicine and Science and completed an internship at Rush University Medical Center and a fellowship in clinical neuropsychology at Northwestern Memorial Hospital. He's the current director of the Isaac Ray Research Program in Behavioral Sciences and the Law, co-director of the Forensic Neuropsychology Laboratory, and assistant director of the Clinical Neuropsychology Fellowship Training Program at Northwestern Medicine. His research investigates the interaction between neurocognition, emotion processing, personality traits, and socio-ecological factors in the genesis of violent behavior. He's published on topics including risk assessment, offender typology, laboratory measures of emotion processing, the relationships between mental illness and violence, and the neuropsychological outcomes in psychiatric and medical disease. The ultimate goal of Dr. Brook's research program is to improve the understanding of interpersonal violence in order to design empirically supported risk assessment tools and community violence interventions. As an educator, Dr. Brook teaches graduate level courses in neuropsychology and behavioral neuroscience and conducts clinical supervision of students, residents, and fellows. As a clinician, Dr. Brook is an attending neuropsychologist at Northwestern Medicine and serves as a consultant for the Intercollegiate Sports Medicine Concussion Program, the Comprehensive Epilepsy Center, and the Brain Tumor Institute. Dr. Brook's practice in the area of forensic neuropsychology involves providing independent consultation to attorneys in the courts for criminal and civil matters, including personal injury, malpractice, fitness, competency, mitigation, and risk assessment. So with that, I'll turn it over to you, Dr. Brook. Thank you.
All right, thanks, Sasha. Share my slides and we'll get going. Okay. Can someone give me a verbal if you guys can see my whole screen and not the presenter view?
Looks great, yep.
Excellent. All right. Well, thanks for having me, everyone. This is fun. This is a topic that I'm passionate about, and I love exploring more. And to me, forensic neuropsychology, like no other area of what we do, keeps me honest, challenges me constantly, and advances my knowledge as a neuropsychologist. So I'm excited to talk to you guys about it. The official title of this talk is Introduction to the Practice of Forensic Neuropsychology, but this is the actual title of the talk. This is the actual title of this is the actual question I frequently get from trainees and early career folks who are kind of forensically curious and they've heard about it, they maybe read a report, and they're interested in knowing more, perhaps exploring into getting into the field a little more. So this is what this talk is. And the mere 45 minutes we have, because I do want to leave room for questions. This topic always generates just a really great discussion. So I want to make sure we have time for that. But in about 45 minutes, I'll give you a very incomplete, non-thorough, brief primer on the issues relevant to the practice of forensic neuropsychology. So this is the outline. We'll begin by just reviewing the structure of our legal system, which tends to be the first step in exploring the interest in forensic neuropsychology more. We'll talk about what makes a forensic neuropsychologist different from a general clinical neuropsychologist. We'll talk about the role of the neuropsychologist as an expert witness in the court system. We'll talk about how forensic neuropsychological evaluation is different from typical clinical evaluation. We'll have a slide on informed consent. We'll talk about most common referral questions that you get as a forensic neuropsychologist, and we'll back up each one of these referral questions with relevant case law. And then finally, we'll talk about sort of how to be an effective expert witness. Okay, let's get going. So in the US and in all the ex-British Commonwealth countries, we use what's called an adversarial system. The common law countries here on this world map are coded in red, but the rest of the world actually does not follow common law. Most legal systems in other countries follow the civil law. This is where it's an inquisitorial system where a judge investigates the case. In our system, it's called an adversarial system because there are two parties which present their case in the court, and each party has their own advocate, their own attorney or lawyer. And then the arguments from the opposing parties are heard by the trier of fact. And the trier of fact is some impartial person or supposedly impartial person, or a group of people like a judge or a jury. And then the trier of fact hears the case and determines the truth based on adversarial proceeding and different types of witness testimony, and then they pass judgment accordingly. All right, so that's the adversarial system. So the common law system, by the way, emerged in England in the Middle Ages, and it's named common law because it was common to all the kingdoms in the British Isles, and we still follow it to this day. So the common law system is really two legal systems, each with their respective terminology, court proceedings, proof of evidence, burden of proof. So the two systems are the criminal legal system and the civil legal system. In the criminal system, the two parties are the government and the person who's committed some sort of an offense against society or the government, right? So in the criminal case, the government attorney, called the prosecutor, brings a case against an individual who's broken the law or allegedly broken the law. Then the defendant is entitled to their own counsel, the defense attorney. The two attorneys from the government or the state and from the defendant present their cases. The trier of fact hears the case, and then the decision of innocent or guilty is made. So this is called sometimes the guilt-innocence phase of the criminal trial. The criminal court system sets a very high burden of proof to find someone guilty. That burden of proof is beyond a reasonable doubt. So unless otherwise specified in law, but most of the time it's beyond reasonable doubt. So the government has to prove beyond the reasonable doubt that the defendant is guilty of the crime they were charged with. So before the sentencing, or sorry, before the verdict is pronounced, sometimes there's some sort of a plea bargain to where the government and the defendant's team agree on some lesser charge in exchange for a guilty plea, right? And this is where the defendant pleads guilty, and then we move on to the sentencing stage. Oftentimes, the plea bargain is not made, and then the proceeding goes directly to the guilt innocence stage. And if the defendant is found guilty, then we move on to the sentencing stage. And neuropsychologists can really become involved in every phase of this process, but most commonly during the post-conviction sentencing stage. More on that in a few slides. So that's the criminal system. In the legal system, instead of the government bringing a case against an individual, it's two individuals going to court because one individual called the plaintiff brings a complaint or a case against another individual who's called a defendant in the system. So the plaintiff is the injured party. So if you think of, for example, a personal injury case, which a lot of forensic neuropsychologists are involved in, most commonly personal injury cases involving traumatic brain injury. So let's say it's a mild traumatic brain injury case, personal injury case against an employer. So the individual who suffered the traumatic brain injury would be the plaintiff, and their employer would be the defendant in that case. Each side, again, is entitled to their own representation, and then the burden of proof is not as high in civil cases as it is in criminal cases. In civil cases, the plaintiff only has to prove by the preponderance of evidence that damages have been incurred as a result of some action by the defendant, right? So not beyond the reasonable doubt, by the balance of probabilities, more likely than not that damages have occurred. If so, then there is some sort of either a pretrial settlement to where parties agree on some monetary payout, or there's a bench or a jury trial, and then the judgment is made. And then the judgment is most typically in term of some monetary reward to the plaintiff from the defendant. And supposedly the judgment, the monetary award, is commensurate to the damages. So as you can already see in a case like a personal injury or traumatic brain injury, a neuropsychologist would opine, provide an opinion, examine the plaintiff, provide an opinion regarding the extent of the neuropsychological damages from the traumatic brain injury. And then based on that testimony, then a certain judgment is made or damages are awarded. Okay. So that's the system. Who then is a forensic neuropsychologist, right? What's different about a forensic neuropsychologist? Well, the answer is not much, right? There's no really special training. There's no special certification that's involved in the practice of forensic neuropsychology. I always tell people to be a good forensic neuropsychologist, you have to be a good neuropsychologist first. And in that vein, forensic neuropsychology is really nothing more than the application of neuropsychological assessment to the legal system. Right? Forensic derives from the Latin word forensis, which means in open court or public. This goes back to the Roman tradition of holding adversarial court proceedings in a public space where both arguments could be heard by some arbitrator and by the public. And current legal practice is very consistent with that notion. We'll talk about that later a little bit, and that your entire work as a forensic neuropsychologist is in the court of public opinion, It is not privileged. Before we started this uh, presentation, I was telling folks that one time my entire report was published in a local paper. Uh, 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 so it's all in a public record. Um, so forensic neuropsychologists are then clinical neuropsychologists with special expertise in several things, and those things are uh, being an expert witness. They have to be familiar with the basics of the legal and the jurisprudence process. They have to be familiar with the relevant case law. And they have to be able to translate the neuropsychological findings into the language that the legal parties can understand. Right? And also, I would say, educate the trier of fact about the strengths and limitations of our methodologies. All of that are sort of special expertise of forensic neuropsychologists that go above and beyond clinical neuropsychology. So then, uh, in essence, forensic neuropsychologists are clinical neuropsychologists who serve as expert witnesses in the court. So who's an expert witness? Who can serve as an expert witness is actually codified in the Federal Rules of Evidence. The Federal Rules of Evidence is a set of guidelines that was first drafted by the Supreme Court and then passed by the Congress in 1975, and it's updated annually. And the Federal Rules of Evidence outline all the procedural guidelines and regulations for a courtroom proceeding. They describe what a witness is. So according to the Federal Rules of Evidence, a credible witness is any person who makes testimony in court or acting otherwise as a witness, whose credibility is unimpeachable, meaning that the credibility of the witness cannot be reasonably called into question. Uh, and the Federal Rules of Evidence also provide specific guidelines for what makes an expert witness. And it also provides admissibility standards for scientific evidence. You know, what kind of scientific evidence meets sort of the basic burden of validity to be admissible in court. So that includes our tests as well. So then specifically with the expert witness guidelines outlined in the Federal Rules of Evidence, an expert witness is a person whose opinion, by virtue of their education, training, certification, skills, or expertise, is accepted by the judge as an expert. And in fact, the first thing that happens when you get up on the stand is your direct examination attorney will establish your uh, 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 competency as an expert witness in the area of clinical neuropsychology, and then submit to the judge your expertise. And then the judge can accept, and the opposing counsel can challenge your admissibility as an expert witness in clinical neuropsychology. Sometimes they do, sometimes they don't, but it's always their prerogative to do. If the judge admits you as a expert in clinical neuropsychology, then you can serve as then you can provide or deliver your expert evidence and your opinions in the case to the court. Okay. So this is the question I get frequently. There's a lot of talk, I feel like, in our field about silent forensic evaluations. This is where a patient comes to see you in the clinic. They suffered a mild traumatic brain injury. and there's a lawsuit pending, all right? And through your interview, you are you become relatively certain that your report will be used by the patient in a court proceeding, right? So this is the situation where you might be deposed. Um, so let me just say that even if you're not interested in forensic neuropsychology, you are going to testify at some point of your career, if not as an expert, then as a treater. So let me then outline kind of the differences between a clinical and forensic evaluation and what makes you a treating provider versus an expert forensic expert. So first, the referral source. In the clinical evaluation, um, the referral source is another provider or the patient is self-referred, but it's a just like any other clinical referral you see in your outpatient clinic, right? And it's a clinical evaluation that then becomes used in a legal context. If you're an expert, then you are specifically retained by a legal entity like a court or an attorney to perform an independent neuropsychological exam and answer very specific legal questions, right? So in addition to the severity of cognitive impairment, prognosis, all the usual things that we answer as clinical neuropsychologists, you're also retained specifically to answer a specific question. As a clinician, your role is to advocate for your patients, right? As an expert, your role is an impartial examiner. So then, whereas a clinician is a patient advocate, an expert is an advocate of the facts in the case, right? It's not your role to advocate for the patient in any way, which can be tough in some cases. And I testified a few weeks ago in a really sad case where a guy who was incarcerated in a federal prison on a weapons charge uh, has untreated schizophrenia. And I could not provide treatment recommendations, right? Because that's not what the attorneys were interested in. They were interested in a narrow legal question. But I was a retained expert, not that patient's neuropsychologist. Your client, in a clinical setting, the patient is your client, right? They have full control over work product. They have full control over their report as a patient, right? Um, as an expert, you don't have control over your report, and the examinee doesn't have control over the report. It's the retaining legal entity, the courts or the attorneys, that that have uh, that have control over your work product. They get to dictate if it's determined or if it's distributed, where it's distributed, or even if they want the report. In many a forensic case, um, I had a preliminary conversation with the attorneys where my opinion was not favorable to their side, and they said, "Oh, no, forget about it. We don't want a report." Right? And in this kind of a scenario, as an expert, there's no obligation for you to issue a report. So that's the client. The payee, in the clinical situation, it's either the health insurance or it's out of pocket. And in an expert witness scenario, it's the retaining legal entity. So the state, the court, or the attorneys who provide payment for your services. The confidentiality standards are different. Your work, your clinical work is protected by HIPAA. You're bound by the APA Code of Ethics to protect patient confidentiality. As a forensic expert, the confidentiality standards are outlined by the rules of evidence, which say that all witness testimony is in public domain. right? So if it's discoverable, it's in the public domain. And you're bound by the APA specialty guidelines in forensic neuropsychology, who outline sort of ethical, if not obligations, then ethical standards for protecting confidentiality of your forensic examinees. Finally, informed consent is required in most cases, not all, but most cases in your clinical work, and it's not required in forensic work. It's ethically recommended and suggested, but it's not required. So then I wanted to include just an extra slide on informed consent. I do provide written informed consent in every case. This is just an example of my form. There are many other examples out there. But these, according to the specialty guidelines in forensic neuropsychology, or in forensic psychology rather, these are the topics that should be covered in any informed consent. And these are the same topics as this, basically. So you cover the nature of the evaluation, who's the requesting party. You have to tell the examinee, or you should tell the examinee, that there's no doctor-patient relationship established from this examination, that there's no confidentiality, and the retaining or the requesting party will control how the information is used. And in my informed consent, I also say that de-identified information may be used for research, but obviously that's not in every case. Okay, so just kind of have this as a handout. Okay, so let's talk about the most common referral questions in the forensic context for neuropsychologists. And then I'll have some case law for most of these referral questions. So insanity, and this is a legal definition of insanity, and I do have a slide on that later, is a common referral question. So this is where a neuropsychologist examines the defendant. They provide an opinion whether or not the defendant meets or does not meet legal definition of insanity as outlined either by federal or state statute. And then the courts use that opinion to assign an appropriate verdict. If the patient or, sorry, the examinee is found to meet criteria for insanity, then the verdict is not guilty by reason of insanity, which means that instead of adjudication, they are then committed to mandatory treatment. There have been several very high profile cases of legal insanity in legal history. The case of Lorena Bobbit was one that made headlines in the 90s. You may be familiar with it. In case you're not, Lorena Bobbit was a woman who suffered years and years of physical and sexual abuse by her husband, an ex-Marine. And the years of abuse culminated in Lorena Bobbit, let's just say, depriving her husband of his most treasured possession in a quite violent way. She was charged with a violent crime. The defense experts testified regarding the post-traumatic sequelae of abuse, and what at the time was referred to as the battered woman syndrome. It was actually a syndrome included in the ICD-9 at the time. It didn't make it into ICD-10. ICD-10 talks about just kind of general sequelae of PTSD in the same kind of vein. And so the jury found her not guilty by reason of temporary insanity, and she was sentenced to go through a 45-day evaluation period in a mental hospital and then released into the community. And then like I said, I have another slide on the federal definition of insanity later. Um, a number of questions relating to competency is also a very common referral question for a neuropsychologist. Um, this could be, and in this competency in our line of work refers to mental capacity to make a specific decision or participate in a certain activity. So it could be competency to stand trial, could be competency to waive Miranda rights. So Miranda rights is when you get arrested, the police officer, when arresting, has to read Miranda rights, which is basically says that you have the right not to incriminate yourself and stay silent, and that you have a right to an attorney. Right? And if a suspect waives the Miranda rights, and then provides a self-incriminating statement sometimes later during the trial, their attorney would challenge whether or not they had the mental capacity because of a intellectual disability or a mental illness to have waived Miranda rights knowledgeably. Right? Um, the competency question could pertain to making healthcare decisions for yourself, or competency to independently manage your affairs or finances. There are many different competency questions that can be brought up in the forensic context. And a lot of what I do with attorneys to begin with is to really, if it's a competency question, to really zero in what is the competency for? Because competencies are not global. They're specific to an issue, and in some cases, they're time limited. So that's the competency realm. Another, probably the most common referral question is post-sentencing mitigation. This is where a defendant has been convicted of a crime, and then their attorney suspects that there's some mitigating condition, a neurodevelopmental disability, or an acquired neurocognitive disorder, or a mental illness like an access to disorder that could serve as a mitigating factor during the sentencing stage. So they could get a lighter sentence. Um, and so then as a neuropsychologist, you would examine the patient and provide diagnostic opinions that could be then used by the courts for mitigation, post-sentencing mitigation. Another common referral question is to evaluate the extent of neurocognitive or psychological injury. The NFL concussion lawsuit, in which a lot of neuropsychologists are involved, and it's happening right now, is a really good example of this. This is where the ex-NFL players reach the settlement with the NFL, where they get a certain amount of damages based on the extent of neurocognitive injury they received as a result of concussions sustained during their careers. And it's been a highly contested, a very controversial topic for several different reasons, for which we have no time to get into today, or perhaps we'll get into during the Q&A portion of this talk. But under the NFL settlement, the ex-players are entitled to monetary damages based on the extent of neurocognitive dysfunction. Literally, if it's 1.5 standard deviations below the mean, they get this much. If it's 2.5 deviations below the mean, they get this much. So you can probably already start seeing the all kinds of ethical and practical challenges with that, and we can chat about that during the Q&A session if you like. Disability or return to work is a very common referral question in the civil law realm. In addition to the extent of neurocognitive or psychological injury, this is where a claimant is applying for disability based on traumatic brain injury or a neurocognitive disorder or anything like that, or they are attempting to get clearance to return to work after they've recovered from some kind of a cognitive disorder. And then lastly, a common referral question has to do with peer review of another neuropsychologist's forensic independent evaluation. Now, in the adversarial system, as we talked about before in the beginning of this talk, each side is entitled to their own expert. So oftentimes, especially in civil cases, the one side will want an independent neuropsychologist to review the opposing neuropsychologist's work and basically provide opinions regarding whether or not the other neuropsychologist's diagnostic opinions were supported by their data. Okay. So these are the common forensic, kind of most common forensic referral contexts. So let me provide you with some sort of seminal statutes and cases that inform a lot of the forensic neuropsychology work, probably 80% of the work that I do as a forensic neuropsychologist. So just so you have familiarity with them. So this is US Code 18, paragraph 17, that provides a federal definition of insanity. And this is a federal definition that's used by the federal court system, and each state has their own definition of insanity that is usually pretty close to this definition. And so, according to the federal statute, a defendant meets criteria for insanity if, at the time of the commission of the offense, as a result of severe mental disease or defect, they were unable to appreciate the nature and the quality of the wrongfulness of their act. And so if someone, by virtue of some kind of a mental illness, so I mentioned the case of Lorena Bobbit before, and the case of PTSD, these cases are exceedingly rare. And in fact, defense attorneys will rarely pursue an insanity defense because they rarely succeed because the burden of proof is so high. So you have to prove beyond a reasonable doubt that at the time of the commission of the offense, the defendant wasn't able to appreciate the wrongfulness of their action, right? So aside from severe psychosis, it is really difficult to meet this burden of proof. So the insanity defense comes up most frequently in the setting of severe psychotic symptoms, or less frequently intellectual disability. So that's the insanity statute. Let me talk about a few Supreme Court decisions that are really important to forensic neuropsychology work. A moment ago, I mentioned that competency to stand trial is a common referral question, and it is. And it was the 1960 Supreme Court case, Dusky versus the United States, that outlined the criteria for competency to stand trial. So this was a case of Milton Dusky, who was in his 30s at the time of the offense. He was charged with assisting in the kidnapping and rape of an underage girl. He was clearly suffering from schizophrenia at the time, but was found competent to stand trial and then received a 45-year sentence. And then it was petitioned to the Supreme Court, and the Supreme Court found that he was not competent to stand trial, and the Supreme Court issued 3 criteria which have to be met, in order for the defendant to be competent to stand trial. And these are, the defendant has to have a factual understanding of the courtroom proceeding. So the defendant has to know what the role of the judge is, what the role of the jury is, the prosecuting attorney, the defense attorney. They have to have a rational understanding of the legal proceeding. What does the legal case mean for their future? Can they reason through the costs and benefits of accepting a plea bargain? Things like that. So that's the rational understanding. And they have to have a rational ability to assist their attorney with their defense. Right. So they have to be able to have enough cognitive, mental, psychological competence to be able to rationally assist their attorney in their case. Okay, so if someone is found not competent to stand trial by a competence exam by a forensic psychologist or a neuropsychologist or a psychiatrist, then an order of restoration is issued, and then they are remanded for restoration of competence. So I recently testified in a case where I thought the defendant was not competent. This is the same case I mentioned earlier, by virtue of having untreated schizophrenia, but could be restored to competency with consistent treatment of psychotic symptoms. So this is where remanded to restoration, they're treated, and if they're restored to competence, then their competence is reassessed and they can go through their criminal proceeding. Okay. In some cases, such as in cases of intellectual disability, someone can be found permanently not competent to stand trial, in which case they're remanded to a secure mental institution in lieu of undergoing trial. You may have heard, if you're following the news, you may have heard about what's called a competency crisis in the US, where there's been an enormous exponential increase in requests for competency hearings or competency exams in the country, and the number of people who are found not competent to stand trial, and a huge demand for restoration services that has not been met. So this is a very hot topic in in the field of forensic psychology and neuropsychology. And if you practice forensic neuropsychology, you'll probably do many competence evaluations. Okay. Atkins versus Virginia was a Supreme Court case from 2002. Daryl Atkins was convicted of abduction, armed robbery, and capital murder. Here you see ATM footage of his victim extracting cash from the ATM. He later brutally murdered this victim. You can see him in the back seat here. A forensic psychologist testified at the trial of Atkins that he had mild mental retardation. That's what it was called at the time. And the jury sentenced Atkins to death in Virginia. It was appealed to the Supreme Court. And in a 6-3 decision, where the majority opinion was issued by John Paul Stevens at the time, the High Court sided with Atkins. And they said that, yes, the capital punishment, when applied to an individual with an intellectual disability, violates the Eighth Amendment that prohibits cruel and unusual punishment. Interestingly, this is a part of their opinion that I find particularly interesting in our work. They wrote that they had serious concern whether the basic justification underpinning the death penalty, which is retribution and deterrence of capital crimes, even applies to offenders with intellectual disability due to their lessened culpability. So it's a very important case to neuropsychologists in the criminal realm. This is a case of Miller versus Alabama at 2012 Supreme Court case. Evan Miller was convicted in 2006 of killing Cole Cannon, who's pictured here, by beating him with a baseball bat and then burning his trailer while he was still inside it. Miller was 14 at the time of the offense, and he was sentenced to life without the possibility of parole. It was appealed to the Supreme Court, and the question before the High Court was, does the imposition of life without parole for a minor violate, again, the Eighth Amendment's prohibition against cruel and unusual punishment? And they ruled yes, that it does. It was a close 5-4 decision where the majority opinion was issued by Elena Kagan. And part of the decision was the implication that now lower courts are required to conduct new sentencing hearings, post-conviction sentencing hearings, where the judge has to consider the child's individual character, any neurodevelopmental disorders, life circumstances, as well as the circumstances of the crime in resentencing. So a lot of these cases are still making their way through the legal system. And we as forensic neuropsychologists get retained to examine the defendant, who can be in their 50s, 60s, 70s, right now. And our opinion is, and we then provide an opinion that during the commission of the crime, when they were like 15 or 16, was there any kind of a neurodevelopmental or any other condition in play which could serve as a mitigating factor? So that's Miller versus Alabama. Okay, so I just wanted to mention a few of these cases. There are many more, but these are sort of the most kind of cornerstone cases that you should know. Okay, a couple of more slides, and then we'll do a Q&A. So then the role of a neuropsychologist in the courtroom is as an expert witness. So there are two types of expert testimony. One is courtroom testimony, which is what you see on TV. And more commonly, actually, it's deposition, which is out of court oral testimony, pictured here, of an expert witness that is recorded and can be reduced to a transcript, that the transcript can be later used in court or for discovery purposes. And if you testify in deposition, you may or may not be additionally asked to testify in court about the same case as well. The parties involved are the attorneys on behalf of the state or the plaintiff or the defense, depending on whether it's a criminal or a civil case. There's a court reporter always present. There are expert witnesses, who is you, and then the trier of fact, which could be a jury in a jury trial, or a judge in the bench trial, or an arbitrator in a civil case, or some kind of a hearing officer if it's an administrative hearing or anything like that. There are specific steps outlined in expert testimony. First, your attorney establishes your qualifications as the expert witness based on your CV, credentials, and typical practice. Then there's direct examination, where the attorney who retained you asks you about your opinions. And then there's cross-examination by the opposing counsel, who then has the opportunity to challenge your opinions. I wanted to include this slide as a handout for you to have just some tips and tricks for being a successful expert witness. Books have been written on this very topic, so this is by no means an exhaustive list, just some bullet points. This is what I try to do before preparing for testimony. You sort of have to understand your role first, which is the educator of the trier of fact. Your role as an expert witness is to educate the courts on your opinions, right? Including the strengths and limitations of our methodologies. Over prepare. You know you will be examined, you know you will be cross-examined, you know the questions are going to be tricky, so over prepare. Know your report inside out. And I always schedule a prep session with the attorney. And if possible, I try to schedule a prep session with a colleague of an attorney who's not familiar with the case. I can sort of try to anticipate some questions that might come up on the stand. Leave your ego at the door. This is not the time to be defensive. This is, again, this is the time to act as a teacher of the court. So during when you're on the stand or during deposition, you want to kind of project the persona of a calm, knowledgeable expert. I think of Obi-Wan Kenobi all the time, sort of not getting flustered. You speak directly to the trier of fact. You state your opinions with a reasonable degree of neuropsychological certainty. Take your time before answering. You're being paid by the hour. Don't give in to tricky or leading or double negative questions. You know, don't give in to a simple yes or no question if it's not a yes or no question. So, you know, in a concussion case, on cross exam, you might be asked, "Is it true, doctor, that traumatic brain injury results in widespread damage to the brain's white matter?" Right? And so the short answer would be yes, but what they're trying to do is bring fact that is true of moderate to severe traumatic brain injury, not so much of mild traumatic brain injury, and make it applicable to mild traumatic brain injury, right? So this happens a lot. They use a lot of tactics like this. Don't accept opposing counsel statements as fact, as I said, because a lot of the time it's not. Saying, I don't know, it's perfectly acceptable. It's perfectly fine to correct your mistakes on the record. If you make a mistake, in fact, it's highly encouraged. And then if you become overwhelmed or tired, it's always fine to request a recess. Okay, so this was an incredibly brief run through introduction to forensic neuropsychology. Where can you learn more, right? If you want to explore the topic a little further, here's what I suggest. Get to know a neuropsychologist who does forensic work. Ask to shadow a deposition. Most people will be more than happy to let you do that. Sit in on courtroom testimony. See how the sausage is made. Read through the APA specialty guidelines for forensic psychology. Attend an APLS meeting. This is the American Psychology and Law Society. They're great meetings. I just came back from one last week. Really high quality of research. A lot of really great practical issues are raised. And then these are the books I really like to learn more about the topic. So you can have it as a handout again. Okay. I only left 5 minutes for questions, but I am more than willing to stay a little longer if you guys are. Okay, thanks for your attention.
Thanks, Dr. Brooke. That was a really informative lecture. We definitely do have some questions. I think you actually preemptively answered a couple of what would be next steps for getting some resources. So I appreciate that. I'll just jump right into the Q&A then, because we have a few in here. So somebody had a question about, I guess, payment. I guess they're referring to the slide you had about who is the client. They say, so what would you do if a lawyer wants to run the evaluation through their client's health insurance?
That's a great question, and sometimes that happens. Um, so you would counsel the lawyer in that scenario that um, as a patient, so then the client becomes your patient, right? And as a patient, they have complete control over how the product is used, right? And if there is a clinical indication for the evaluation, you're not doing anything unethical by seeing the patient, right? You would anyway if they were referred by their primary care physician or psychiatrist or whoever it is, right? But this way, you're conducting a clinical evaluation. You are not answering any legal questions, right? So you're answering your typical clinical question, which is the diagnosis, recommendations for further treatment, prognosis, but no legal opinions. And you should be very clear about that with attorneys. And then if the patient doesn't like what they see in the report, they don't have to share it with the attorney. After that kind of an explanation, most attorneys say, "Oh no, that's too restrictive. I don't want to do it." Um, and most of them will just go through the forensic route, which is uh, 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 sort of retaining you directly or through your institution um, as a forensic expert specifically for their case, and then they get to ask you questions. So, for example, in a mild traumatic brain injury case, they might ask, can you specifically provide an opinion of how this traumatic brain injury impacts this individual's return to work or in other capacity, right? And you'll answer that question. Um, I should mention another thing related to that question is that um, some forensic practitioners are in private practice and they set out their own rates. Um, recent practice surveys found that there's a huge variability in rates set out by forensic practitioners, with women setting out lower rates than men. Surprise, surprise. So let this be a lesson. Do your research. And because there are not standards, but you can find out what people in your area are charging, right? I don't do this work independently. I do this work as part of a forensic psychiatry division in our psychiatry department. So then lawyers actually contract with Northwestern. And then Northwestern bills for my services, and I just get RVUs like I do for any patient, right? But then the rates are institutional rates, which are typically higher than private practice rates. All right, good
Oh
question.
yeah, that's good to know. Yeah. Uh, so I think we are coming up at the end, but I was just thinking, as you were kind of running through competency to stand trial and the different aspects, the rational understanding of the proceedings, the ability to consult with counsel. I was just thinking about how it sounds like that would require a certain amount of intact executive functions specifically, and abstract reasoning, a certain amount of cognitive flexibility. And so I'm just curious about what we know of how maybe executive functions or other cognitive domains relate to one's ability to be competent to stand trial. And then a related question to that is if there are any standardized measures that have been developed for assessing competency.
Yes, those are great questions, Sasha. Yes, and so let me answer your last one first. Yes, there are standardized, validated measures, and I always use them. You don't have to, but I always recommend using measures that meet the standard of proof and that will really um, validate your testimony in the court. So there are measures to assess specifically competency to stand trial, competency to uh, uh, make an informed decision about Miranda rights, about financial decision making, about ability to make decisions about your own medical care. There are instruments for every single competency decision, uh, and it's beyond the scope of this talk, but you should definitely research them. Executive functions. Yes. I laugh a little because the standards are so low. Um, I recently testified in a competency case of a young man whose IQ is 55. There was there's a federal case. A Bureau of Prisons psychologist uh, examined the patient before me, or the examinee before me. They came up with the same IQ score, and their opinion was that he is competent to stand trial. As neuropsychologists, we would argue how anyone with an IQ of 55 could have a rational understanding of what courtroom proceeding means in their case to be able to assist counsel in their defense, right? But the Bureau of Prison Psychologist, which shall remain unnamed, um, testified that the defendant knew what the meaning of the judge is, and their literal testimony was, when I asked the defendant what the role of the judge is, the answer was to judge. And that was deemed as an acceptable answer. So yes, Sasha, you're absolutely right. There is a lot of executive functioning that's involved in rational capacity to stand trial, but the standard is so low that unless someone is just acutely psychotic or they have moderate to severe intellectual disability, the chances are is that the system is going to deem them competent to stand trial.
All right. Well, thank you for that information. I think maybe one last question. We're a little bit over time, but I was curious about, I think this had come up maybe from a couple different people, in terms of getting credentialed and doing forensic work. I think I'm aware that there is board certification in forensic psychology. And so I was curious what your stance on would be on getting double boarded in clinical neuropsychology and forensic psychology, and whether there are advantages to that or whether it would be worth it.
Yeah, well, you guys asked some really great questions. This was a topic of a very hotly debated issue on the listservs. As you may know, a forensic neuropsychology subspecialty was proposed and then eventually not pursued by Absent. Um, and I actually agree with that decision. There are a few, it's rare, but there are a few neuropsychologists who are double boarded in forensic psychology and clinical neuropsychology. Um, it's not very common uh, because it is a bit redundant. Um, as a neuropsychologist, you have unique expertise in brain behavior relationships. And these are the cases you would testify about in the courts. Forensic psychologists are involved in a larger criminal justice system, including restoration services, uh, mental health, provision of mental health services to incarcerated individuals, all kinds of evaluation services. There's some overlap, but neuropsychological testimony in the court is unique. Um, so there's no extra certification, and I doubt there will ever be one. And I really would question the utility of double boarding. Um, I have never been not admitted as an expert witness in neuropsychology in court because I didn't have an additional certification in forensic psychology. You should definitely become boarded in clinical neuropsychology because that gets brought up on the stand all the time. But one board certification is more than enough to make you eligible as an expert.
Great. Well, I'm sure I could ask you many more questions, but I want to be respectful of your time. Thank you so much, Dr. Brooke, for this great lecture. Um, and I want to direct folks' attention to the next lecture that we'll be sharing next week on April 8th. And that's Towards Open Science in Neuropsychology, brought to you by the Cultural Neuropsychology Council. All right, thanks again, Dr. Brooke.
Thanks, everyone. Bye bye.